Ladies and gentlemen, a warm welcome to our education session today on legal education, teaching, or technology. We have a very distinguished panel of experts to speak to you, and they've been carefully selected to have radically different views and hopefully conflicting views to keep you awake after last night's parties. They range from the very traditional to the incredibly cool and trendy.
Thank you.
I was going to say I'm not going to tell you which are which. You're going to have to work that out for yourselves, but I don't think you'll have too much difficulty. Each of our panelists is going to tell you how they teach the law now and where they see legal teaching moving in the future. And it's very important in that regard that we have a wide spectrum of views, because you, the audience, have a critical role, and especially the students here who've been helping with the forum too, because education is all about students. They're the foundation of all of our law in the future and all of our societies in the future. And in many respects, whilst they've been helping us to enjoy the forum, they are the focus and purpose of the forum. And it's very important that they comment on what the speakers say, that you all do. You tell the speakers whether you like books, you know, those old dusty things that operate on the hinge principle, or whether you prefer to do your work on a laptop, whether you want to see your professors every day, or whether you would just like to tweet to them once a month. But anyway, you express your views, you take a view on what the speakers say, and let's have lots of questions to each of the speakers and at the end. Well, I should turn to our speakers. First of all, I should say that I would like comments from the students here especially, and I know that a lot of them are from St. Petersburg University. Now, if they are controversial comments, or if they're rude, or if you want to say that the way of teaching is not really what you like, you're very welcome to pass me comments like that anonymously in writing, because our very first speaker is the Dean of St. Petersburg Law School. She is a lawyer of great distinction, a professor, head of the Department of Public and Administrative Law, and of course has had tremendous success with her faculty. It's produced some very distinguished lawyers, including one of our panelists today, and some of those lawyers have had quite successful second careers in politics. So I would like to welcome our Dean of St. Petersburg Law School, Ms. Natalia Shevaleva, to tell us about the teaching of law in Russia. Thank you.
Thank you very much, Mr. Chairman. Dear guests, I'm the first speaker for today, and I have to bear a special kind of responsibility because I have to set the topic, I have to set the theme. And as a good student, I tried my best. I wanted to meet the objectives and tried to somehow heighten and highlight the problem of what is the most important aspect of legal education. Do we want to follow the traditional approach, the one that we have grown accustomed to, including myself, or do we want to search for other approaches that the modernization and the development of society may call for? So, in this somewhat artificial conflict of interest, I wanted to find an answer to the question, do we go for school or for technology? The teaching method that we currently use, from my point of view, is not just a mere transfer of information. We transfer information that can be digested and applied in the future by our students. So we're talking about skills, we're talking about ability to use the knowledge. And so in a way you can divide the various teaching methods into the traditional and modern. The modern methods would cover the variety of different approaches that are offered by the modern IT technology. There are a lot of interactive methods. The methods that have been prescribed by the new government educational standard. And the fact that we now have to use the new technology that has been prescribed in the legislation of the Russian Federation is proof to the fact that the Russian legal education is at a crossroads. So right now we are not discussing how to teach, but rather what to teach. And of course the method is just a derivative of that. Do we want to concentrate on what we have always been doing, or do we want to deviate from that? And we cannot deny that traditional teaching methods have proved very efficient. These are proven methods. Teachers and trainees, teachers and students are in close proximity. They interact face to face, and teachers transfer what they have learned themselves. They give that knowledge and skills to their students directly. The history of our civilization shows that this method is quite successful. However, in present day, we face a huge amount of information, and this amount of information is very difficult to take and digest, even in the course of the entire life. And this may give us a hint that maybe we should do some changes to how we teach. There's so much information. There's so many things that students have to learn in the course of their learning at the university. There are certain limitations as to how this knowledge can be transmitted to students, and we cannot ignore these limitations. The current situation is such that we cannot ignore these limitations. My personal view is that it takes at least a year to study the Russian tax law. And if you want to study foreign tax law and international tax law, that's another year. So you cannot spend 2 full years to study only tax law. And you can understand this is not the only type of law that we want to teach. If we teach law in this way, then it would take several decades to learn everything there is to know. This is not an efficient method. So clearly we have to find alternative methods. So the methods that I call modern methods of teaching, they're essential, they're dictated by life itself, and they can be explained by 3 reasons. So first of all, there's so much information which has become the result of the scientific advancement and progress. Then we have a very limited time in order to teach students. The economy is waiting for our students, and we don't want our students to enter the market only when they have learned everything and when they are already mature, if not old. They have to be productive. And there's another point. The employers are looking for lawyers who can apply their knowledge and skills immediately. They don't want to train them additionally. These are the expenses that they believe are not worth it. They want an expert with a degree to be a ready product. They want these young lawyers to be able to work from day one. This would be an ideal situation, and yet we have to keep this in mind.
Далее. Есть еще Три обстоятельства.
There are three other points that I would like to pay your attention to. I believe they are of great importance. Number one, that's probably one of the most important factors. I have it's number 3 on my slide. The students have changed. We're talking about a completely different generation of students. They have grown in a different environment. They know how to work with information, and it is not the kind of processing that we have been used to. They are waiting for different things from the school. They believe that they will get education the same way they used to get knowledge at school before they entered the university. They expect us to be able to use the technology that they are very comfortable with. The internet, the databases, all of these methods that are very accessible, available, and are easily applied by the young generation. A few decades ago, our society was very different. And this is something that we should also keep in mind. And let me digress here a little bit. Let me give you an example. My first PhD dissertation, I remember I typed it on a typewriter. So it was a different world. And when I wrote my doctorate dissertation, I used a computer. I used different databases. It was a completely different approach to research. So I believe that for our students, going back to the typewriter is something impossible. So all these factors make us realize that the situation is extremely different. The situation in Russia can be characterized by the fact that we have new government educational standards that require competency approach, which includes the following factors: technological, social, and economical. This means the students should not only be equipped with knowledge, which is clear to all of us, they should also have skills. They have to acquire skills while they are at the university. There's one more thing that we have to take into consideration. We're not talking about huge volume of information, legal information, other information. We should also remember that this information gets updated very quickly. And this means that we have to teach our students not only to be able to process this information, but to continue to learn, because this only will make them successful in the future. Unfortunately, I'm forced to say that the role of the teacher with the capital T, has changed. In the past, the teacher, the professor, was the only source of knowledge, the only authority, and everything else available around was checked against what the teacher would tell you. Today, our students have all kinds of sources available to them, and it is important for them to find their way in the maze of different sources, in the ocean of this information. And this means that we have to instill certain values. This value approach is the school that I started with, which I put against technology at the very beginning, and that's why I believe that this gap is artificial. I think there's no contradiction between the school and technology and the new technology. We cannot ignore technology, but the technology is going to be efficient. It will be successful only when it is used in combination with the school that will instill knowledge, skills, and values. Thank you.
For that introduction. It did set the scene, and it's very impressive to see both tradition but receptiveness to new methods, and also a readiness to try to deliver what employers would like for young lawyers. Our second speaker is Timothy Endicott. He is the Dean of Law at Oxford University. In an unguarded moment the other day, the forum is very good for generating unguarded moments. He did tell me that if he were not a lawyer, he would like to be a decorator because he finds painting relaxing. Well, I hope he's not too relaxed today, but he is going to paint you a picture of 21st century law in Oxford.
Thank you very much, Michael. There's a picture of my university on the left, and I'm going to tell you a bit about an extraordinary form of legal education. I will spend a few minutes explaining how we teach law to students in Oxford. And the point of that story about how we teach is to point out how extraordinarily diverse good teaching methods can be in legal education. I hope I'll establish this point because what I'm going to describe to you is bizarre from the point of view of a Canadian law student at University of Toronto Law School where I studied law. The way we teach in Oxford is strikingly different from that. And I want to raise the question, is there a core? Are there common purposes that everybody involved in legal education ought to be pursuing? And of course, you'll see the connections with what Dean Shevelova has been saying. And I will say that there are some common purposes that should inform everything that we do. And yet those common purposes leave room for a most extraordinary diversity of good techniques of legal education. I think that's the only picture of an old building that you're going to see on my slides, because the law faculty at the University of Oxford is actually quite new. There's our building. It's a monument of mid-20th century brutalist architecture. The architects had gone to Scandinavia and came back with some rather severe ideas. And this building was built in the early 1960s. And really, the law faculty, as we know it today, is only about as old as that building. This latest picture is part of the building that we've reconstructed. And we managed to convince the heritage people in England, who are very careful to preserve their architectural heritage, even if it's from the 1960s, that we could do something brilliant, and we're remodeling this 1960s building. So the law faculty is not only fairly new, but it's constantly changing and under reconstruction. There's a rather monumental library, still at the heart of the law faculty in the University of Oxford, a huge library with a huge amount of material on hard copy. Now, here's the beginning of the history, and I'm going to tell you the history of 800 years in only 2 minutes, because it's really just a backdrop to what I want to talk about. We've been studying law for 800 years in Oxford, and we got going late on the project started in Bologna of reconstructing the civil law from the Roman law materials. And that was civil law in our university, and we also studied the law of the church. Canon law, we had degrees like other law schools in the laws, the two laws, canon law and civil law. And 400 years ago, the tyrant Henry VIII nationalized the church in England and prohibited us from teaching canon law. And after that, we only had civil law. We have a Bachelor of Civil Law, and our honorary degree is a Doctor of Civil Law. And we still weren't teaching English law. In 1758, we hired the first professor in the English-speaking world to teach the common law, William Blackstone, the Vinerian professor of English law. Today, the English think of him as a historically interesting figure. The Americans think of him as an oracle, as an authority on what it was that they kept when the Americans threw away the British Constitution but kept the one element in it that they found useful in a new nation, which was the common law. And William Blackstone became their authority on what it was that they kept when they kept the common law. We didn't have a degree in English law. William Blackstone was giving lectures to interested people, and it wasn't until the 1870s that we started teaching English law. And you can see why I say that this is a fairly young law school. There are some pictures. You'll see some very senior men with white hair, but most of our people are very young. The students are more than half women. The law faculty membership is about 35%, 40% women. So it's changing, and most of us are quite young. It's a changing law school. We have 225 students a year in a 3-year undergraduate law degree. And this already is different from North America and similar to most of the countries of Europe, because we teach law to students who've just left home and are still growing up. We have the largest doctoral program in the English-speaking world, I think. Somebody tell me if I'm wrong. We have over 200 doctoral students. It's a major part of what we do, right at the center of the law school. And we have master's degrees in criminology and a wonderful collaboration with our business school in law and finance. And we have general law degrees. The Bachelor of Civil Law is still a degree in the University of Oxford, but now it's not a degree in civil law, and it's not a bachelor's degree. It's a master's degree in law in general, and the MJur is similar for students from a civil law background. And we have no LLM. We don't have an LLM because we have the BCL and the MJur. And we don't just like the different titles for historical reasons. It's important to us to point out to the world that they're different from an LLM because we teach them in tutorials. And tutorials are so important to law in Oxford that I'm going to have to tell you a little bit about them. With our law students, we don't walk them through the subject the way a good professor would walk us through the subject at University of Toronto Law School, or I think in any law school in the world. We send the student away and tell them to read a lot of material on a subject, to write an essay answering a difficult question, and to come and explain the subject to the professor in a tutorial. And that's an extraordinary form of teaching. It means that the student has to do some work without having the subject explained to them, write an essay, and get a response from the professor. It means they get a lot of face-to-face response from the teachers, but it also means that they have to take an initiative and take a responsibility for their learning. And if we do what we do right, we don't tell them what the law is, we respond to their defense of their own opinion as to what the law is. The syllabus is quite extraordinary. I think that it's true that no other law degree in the world gives the students so little choice. I think that no other law degree in the world depends entirely on examinations at the end of the program, but maybe somebody will correct me on that. And I think that there's no law degree in the world that assesses students solely through 3-hour closed book examinations. The subjects that we examine in the first year are constitutional, criminal, and Roman, and then you'll see the list of subjects at the end of the program. We examine students in the core of private law, but also in administrative law, European Union law, jurisprudence, and 2 options at the very end. I think it's quite an extraordinary benefit of our law degree that the students write an examination in contract law at the end, instead of studying it in the first year and then moving on to company law and family law and labor law the way we did at University of Toronto. It has some remarkable drawbacks, this form of education. I think that it would be good if we gave the students more choice. And yet, in reviewing the curriculum in the past year and a half, my colleagues have decided that we're doing some distinctively useful things, and rather than change and secure the benefits of a law degree in the University of Toronto or University College London, it would be better to keep on doing the distinctively useful things for lawyers that we're doing in this extraordinary and rather bizarre curriculum. And that involves advanced study in the core subjects. But it has the obvious drawbacks. And we do something unique in our graduate program, which is that we give tutorials for the BCL and the MJur. There, the role of tutorials is somewhat different, and students have seminars in competition law or legal philosophy or corporate law before they have tutorials. And the tutorials are an opportunity for them to do what the professors were doing in the seminars. But again, they're writing essays and getting a response to them from the professors before they write their exams. And that's a useful form of teaching, I think. Now, I've got to my question about whether there are any common purposes for legal education and I wonder if there are any common purposes that you might say rule out certain forms of legal education. And I think there's an extraordinary potential diversity of good ways of teaching lawyers. A tremendous amount depends on what can be done well in a particular country, in a particular culture, in a particular part of the worldwide legal services industry that we're all a part of today. And of course, in a particular university or other educational institution. So there's a terrific diversity. We shouldn't be trying to copy each other, I think. We should be trying to do what you should be trying to do what you're good at, and we should be trying to do what we're good at. And Oxford in particular does not offer a model that I would recommend that you copy. That would be a bizarre thing to do. But I do think, in spite of all this, that we have common purposes. We can potentially learn from each other about how to pursue them. What are they? Well, it has to do with the goal of education, which Dean Shevalova has mentioned. And I think it involves what the lawyer's toolkit. And if I may, let me give you this summary of the lawyer's toolkit. It includes a lot of things: social skills, IT skills, negotiation skills, the ability to be confidential, the ability to make appointments on time, ability to form a network, and so on. Ability to function as part of a business organization, a sense of justice, and the ability to act with integrity. That's a large part of the lawyer's toolkit, and a university isn't necessarily the best place to develop all that. But the lawyer's toolkit does include skills that a university ought to be good at delivering. I'm an aficionado of university education for lawyers. I think that a university has something to contribute to the toolkit. And here are the essential tools in the kit that the lawyer needs that a university ought to be good at developing in students: effective reading, writing, and oral communication. You'll notice, by the way, that I haven't said much about technology, and I'm not going to. But technology, and here I'd agree with Dean Shevalova, has transformed the first of those skills. Effective reading is different when you're working with the massive resources of information technology that are available to the student and to the academic today. And I won't go into that, but a university in this age of information technology ought to be good at handling and equipping the student to handle that technology. Writing hasn't changed as much. Of course, it has changed since Dean Shevalova and I were using typewriters. It hasn't changed as much, and it's still an essential skill for lawyers. And oral communications is as it ever was. I think it's just that you can actually talk to more people using the technology. The ability to make a good reasoned argument, that is a skill that a university ought to be able to impart to students. And finally, close familiarity with the principles, techniques, and processes of the law. A university ought to be good at delivering these things to students. So, in my view, a university law school should equip students with those parts of the toolkit that a university is uniquely well placed to deliver. Those include reading, writing, defending an argument, and close familiarity with the principles of the law. And I think that's just about it. Those are the things that a university really ought to be good at. A university might do other good things. I don't think it's actually essential for a good university law degree in the 21st century that the university should have any course with the phrase lawyer's ethics in it. This is controversial. And I think it's a matter of whether the university is the best place to equip the law student with what they need to perform with integrity in their role as a lawyer. Now, of course, a lot of what they need for that purpose they got from their mother at age 2. And some of what they need for that purpose they need to get from their legal profession as they develop in their career. So there's a continuing role for ethics education for lawyers. But the role of the university, I think it depends on what the university is good at. So if a university law school gets across to students those core skills, then it will be equipping them to work well as a lawyer and doing what a university ought to be doing. In order to give the students a close familiarity with the principles of the law, a university needs strength across the core of the legal discipline. And I'm not going to say anything too controversial about what's in and out of the core, but I hope you'll agree with me that we need it. Strength in the law of wills, strength in the law of tax. My colleagues would love to teach 2 years of tax law. Strength in these fields are really important, but strength in contract law, strength in international law, strength in criminal law, and the other subjects in the core are absolutely essential. A law school also should be equipped to encourage independence of mind. That is something that's essential to the lawyer that a university ought to be good at. Universities ought to encourage independence of mind just on principle because they're universities, but law schools and universities ought to encourage it in lawyers because it's a vocational skill. Lawyers will serve the client better if they're equipped to think laterally, to think creatively, and to be prepared to argue for a controversial and novel solution to a legal problem. That's important for serving clients in the global industry of legal services today. So those are the common purposes. I'll stop with those points. A university should do what it's good at and not try to do things that it's not good at. So it should do the parts of the lawyer's toolkit that belong in a university. A law school has to aim for strength across the core of our discipline in order to equip students with familiarity of the principles of the law. And a law school should encourage independence of mind. And maybe everything else depends on the differences among us. And there are some boats in Oxford. Just a reminder that our students don't spend all their time studying law. But boy, they work hard. They work hard because they'll have to face a tutor next Tuesday, and they'll have to write an essay before that. And the essay may be pretty bad, but the tutor will have the opportunity to discuss the subject with them at that point. And that's a distinctively good thing, not something that every law school should try to do. Thank you.
Well, thank you, Timothy. Only an Oxford Don could say that a law school that got underway in 1870 is therefore quite new. But it does seem to have some new tendencies, one of which is the M-Jur. And I know that Timothy is very welcoming to students from Russia who would like to develop some more international subjects, having got their background in civil law. So by all means, if you're interested in that, speak to him afterwards. Our next speaker is Dr. Gaetano Dimita. He is an Italian lawyer, but he's made his career in academia in London. He is the Microsoft IPI lecturer in intellectual property, innovation, and strategy at the Centre for Commercial Law Studies at Queen Mary University in London. Now, a specialism in intellectual property may sound rather dry until you discover that actually he works with video games and pop music. And so you can decide whether he's at the traditional or trendy end of the spectrum. He's going to tell us about Queen Mary's courses and especially distance learning in the 21st century.
Good morning. Sorry, and thank you for the introduction. Now I'm here to talk about teaching and technology, and I'm doing it from a particular point of view because I wouldn't have gotten my job if it wasn't for technology. I mean, what I mainly teach is, some people call it high-tech copyright. I do mainly online copyright infringement. I don't know if you ever heard of BitTorrent or Mega or this kind of technology that permit to infringe copyright online, facilitate copyright infringement online. And then most of my research is mainly aimed at determining, software protectability, patent and copyright, and the use of networks and legal liability for use of network. Recently, we started also teaching and doing research on video games, virtual worlds, social games, online gambling, that are areas in which, created by technology, that create a lot of legal issue that has to be addressed. So, as fundamental part of my teaching, there is the use of technology. This is what I'm actually teaching legal issue in technology. But that doesn't change the way the law is being taught. You'll be surprised that during my lectures in London, I don't even use PowerPoint. I use a flip chart and I actually draw on the board. However, Queen Mary is probably one of the largest LLM programs in the UK. We have over 500 students each year coming to Queen Mary to take an LLM in law with different specialization. One of the largest is IP and computer and communication. And we mainly teach postgraduate. And this is really important for what I'm going to say. When you teach law to postgraduate, the LLM is normally a full-time one-year program that is aimed to give someone that has already a law degree a further specialization in a particular area of the law of their choices. This is the introduction to distance learning. Not so many students that already complete a law degree and that possibly are already working in the field have the time or can afford to actually take a year off, a gap year, to get a specialization in a particular area of the law of their choices. And not everyone can come to London to take that degree. That's why I think almost 10 years ago, Queen Mary started working on their distance learning program. The distance learning program at the moment offers two different specialization areas. One is in computer and communication, and is the one on which I teach, and the other one is on arbitration and mediation. The particularity of our distance program, this is quite old, so it's an old school distance learning program, is a 2 years to 6 years part-time program that is structured in a way to make it perfectly flexible, I would say. You enroll to the LLM, you can choose between 20-25 modules, you can run the module during the year, you can actually decide when and where to take the module. And all this freedom of choices still awards you an LLM at the end. Now, I don't want to get into the detail of the credit system because I guess you're more interested in the way we actually teach it. Because I guess one of the reasons we're having this conversation right now is because lately there's been a tendency to over-discuss the issue of massive online courses. All these courses that universities, sometimes not even university, are offering online. And there is a strong argument that say you shouldn't leave, you shouldn't let only university to teach. You don't have only to create the system from which an institution is providing you with a degree, and therefore this is the only way of teaching a subject. While I'm really into distance learning, I don't agree with this part of the argument. The way we do distance learning, we don't have open courses. I mean, you have to enroll at Queen Mary, you're taking a course at Queen Mary, and we do actually lecture them. The advantage that technology gave us is we don't actually need anymore the physical presence of the student in the same room. 10 years ago was different. Now every single student is used to technology. They use technology even in the lecture, when they come to the lecture in London. I don't know if you, I guess the fellow academics share the same opinion. Now you walk into a lecture theater and you have a wall of laptops or tablets and people even tweeting during your lecture. So the way we approach distance learning is the same, similar way of teaching it. However, they are not in the same room. This, of course, changed a lot the way we address the student. We don't run big courses. I mean, actually, we're approaching it the opposite. One of the arguments for distance learning is that a lecturer can teach 5,000 people all over the world via a web seminar. We actually do the opposite. If you're teaching distance learning, you cannot have more than 5 to 15 students. Because I don't know if you're familiar with conference call. Imagine watching a screen with 15 different faces and have to deal with that. It's really, really difficult. So we have small courses, they're short in time, while a course at the London-based LLM, it lasts a year, is 22 weeks of teaching. For the distance learning, it's only 3 months, because the modules are shorter. This is the only way to actually address the student need and have not only the flexibility of time zone, and most of the people actually have full-time jobs in law firms, so sometimes it can transform itself in a evening law school, because you have to have the child at night most of the time, and you have the issue with the time zone. But we keep it short, because what we try to do, only 2 minutes, what we try to do is to give the constant feedback that is one of the key of university in the UK, even distance learning. So the course is taught on a weekly basis. We have chat session every week. We have task every week. This task gets marked and assigned, and there is this connection with the lecturer that we try to keep. I don't know, we're trying to fake this kind of campus experience, even if they're not physically in the campus. And I have to say, I have only 2 minutes left, this actually works fine. And this is not only because of the program, because I guess the program is good, but also because of the student community. I think that law teaching can be done distance learning easily when you're dealing with postgraduate. They're already lawyers, they're working, they understand what is their part of the deal, and so they're really simple people to teach the law to, because they've already been trained. I have different opinion, but probably we're going to discuss it later during the question time, regarding open web seminars and open degree online.
Thank you very much, Gaetano, for opening the possibility of law to people a long way from London or Oxford. Our next speaker, though, is Vasily Torkanovsky, who did go to Cambridge the year before last. He is a very distinguished international practitioner, and I know that he's been working on some of the largest international litigation that's happened over the last few years. During the course of that, he also managed to do his LLM at Cambridge in his spare time, and he's ideally placed to give us a bit of a comparison of feeling about education here and in Cambridge. Thank you.
Спасибо, Майкл. Я, в отличие от...
Thank you very much, Michael. I act here as a student. I will tell you about the legal education from the point of view of a student, and I would like to offer my view on what's going on and what can be done. I am a graduate of Oxford. That's why I sit on the opposite side from Professor. And let me tell you, there's one more legal course in the world that places a lot of emphasis on the examination at the end of the year. I don't know whether it's good or not, and I will let you decide as an audience, but let me tell you this. I wanted to concentrate my presentation on one element of legal education which strikes every student who wants to compare the legal education in Russia and in the UK, and that is the library. Even though we can talk about a variety of different methods, and obviously you cannot replace the face-to-face interaction with a teacher, I think that the library is an element that brings together modern methods and the traditional methods of education. I may be more conservative in this respect because I like the old-style libraries with dusty books, the ones that I studied. And it seems to me, and here I would like to concentrate on a number of problems, there are two aspects, the two functions that every library plays, and that to a certain degree defines the structure of a learning process. Every library is a source of information, is a source of data that it can be used for studies and for research. Often students in Russia do not have this opportunity. They do not have access to some sources that they may want to read. This is true for many different areas. So, to a certain degree, I think we tend to overestimate modern technology especially on the part of people who put together libraries for Russian universities. And I'm not only talking about university libraries, but about public libraries as well. It seems to me that they believe that if you get connected to a lot of electronic databases, you will be able to replace the paper-based library, and that you would not have to replenish the stock of the library so often. And that leads to some dramatic consequences for libraries. And often you can see that in some libraries you can find publications, paper-based publications, only of the 1980s, 1990s, but no paper-based publications of the past decade. I believe this is a big factor that influences not only students but teachers as well, because students read in the library, they ask relevant questions. So I believe the British libraries here, of course, are of great interest to us. The second function that every library plays, to me, is an infrastructural one. It seems to me that it is a wonderful place to work and study and do research. It's a good location. And a lot of schools in Russia, especially law schools, lack a beautiful library where students could just sit and study. Let's look at Cambridge. The library occupies 3 stories, 3 levels, and I think this is exactly how it should be. The role of every library is more than people tend to believe, especially in Russia. That's basically all I wanted to say. It's a very brief presentation, and thank you for your attention.
Thank you, Vasily, for that trenchant defense of books. For some of us, that's quite a relief. Our next speaker is going to talk about a different topic and a different method of teaching. She is Ms. Maria Isayeva. She is a graduate of St. Petersburg Law School, and in the past she's been a senior lawyer with the Registry of the European Court of Human Rights, and she's now the managing partner of Threefold Legal Advisors. Importantly for today's purposes, she's also the national organizer of the Jessup mooting competition, at least the Russian participation in it. And I understand that she received the Pamela Young Outstanding Volunteer Service Award in this year. It's not often that lawyers volunteer, and she's to be celebrated for that. And I'd like her to give her presentation. Thank you.
Thank you very much, Michael. У российских юристов
Russian lawyers do not often have a chance to represent Russia internationally and at the same time be among the winners. In 2012, a team of Moscow State University students won the worldwide Jessup competition, which is one of the largest international law moot court competitions. I am the Russian administrator of this competition since 2008, and I can tell you this story of success. So let me use this success story as an example, the 2012 story, in order to outline my understanding of the impact that Russian education, school and technology have on each other at present. I hope this was going to be interesting to all. And I urge you not to take what I am going to say personally, because I'm going to talk about systemic things, and they have nothing to do with personal achievements of Russian students, Russian professors, Russian teachers. The Russian legal studies have been severely and adversely affected in the Soviet Union. It was behind the Iron Curtain. It was impossible to access knowledge and information and to exchange freely ideas with lawyers from other countries. Legal studies were also affected by the ideology at the time. This, unfortunately, had severe consequences. Education in Russia still has to carry the weight of this legacy. In the 1990s, when Russian lawyers and lawyers from other countries started to come across each other regularly, they found that they are no longer able to speak the same language. There was a gigantic gap, and often it could not be bridged, in the understanding of legal concepts. The knowledge of newest concepts was limited, and the understanding of classic theories was ideologist. There were difficulties in working with sources of law, as well as there were huge gaps in education. Some of you may say that this is something that has already been mentioned by my colleagues on this panel. Working with different sources of law, libraries. We lack a lot of things that are taken for granted in many different countries that have been developed over decades or even centuries. You may say that this is an exaggeration, but it is not. I will not claim that I know the only solution to this situation. But let me tell you how public access to information and having an international topic of conversation, in this case public international law, can change the situation in this particular example that I'm very well familiar with. As I mentioned earlier, the Jessup Cup is one of the largest international law moot court competitions. This has not always been the case. In the 60s, it was not the largest. It was a regional competition for a while. The format was taking the format of the UN International Court. And if I may,
Switcher. А можно побыстрее их крутить? Вот до 90.
Would you please skip the slides quickly to the 90s? I apologize for this interruption.
This is a session on technology, but I think we begin to see some of its
Почему-то я ее
weaknesses.
остановила. Остановили слайды почему-то.
For some reason, the slides are not progressing. There's no movement of slides. Well, there's no development. Nothing's changing. Well, do you think you could ask someone at the back to get through all these years and reach the 90s? Yes, apparently the competition is a large one. And I'm going to show you what's been happening in Russia. Nobody knows why it has been happening this way. We cannot answer this question. Why is it that this competition raised that high so quickly? Maybe that was the impact of technology. It's very difficult to say. What I wanted to show to you is the growth in the 90s. So when the internet became available, we saw a step forward. We saw a big change, especially compared to the 1960s. So in the 90s, you can see that a lot of different countries in the world participated in the competition. So we can now say that this is a world competition. And in itself, it is one of the most vivid examples that I know of technology affecting education. If you look at the development of the competition in Russia, you will see a unique example of what just access to information can do. Russia's participation in the Jessup Cup in the 1990s was rather sporadic. Only several universities took part in it. Something's happening to the slides. There should be other slides visible already. Anyway, prior to 2002, only 3 universities participated in the competition. And there was the lack of information. First, the Leningrad, now St. Petersburg State University, took part in 2001. Could you go back to the first slide? And could you please stay there? So we learned that the Leningrad, now St. Petersburg State University, participated in the world round, and there was no continuity of information. We learned that the university participated in this cup only from the archives. Then, the information is available only in English. You can see the Russian Association Law Institute. No information was available in 2005. St. Petersburg took part in the competition because it got an invitation from the outside, and it was a lucky coincidence. So the team got together and went to participate in the competition. But in 2002, the head of the Moscow office of one of the legal companies decided to organize a national round in Russia to bring together several Russian teams. The administration team started sending out letters to the various universities, calling the universities, trying to bring them together. And there were 14 Russian teams that took part in the Cup in the first year. By comparison, the UK and Germany have been historically sending the same number of teams. And many European and Asian and Latin American nations have been sending far fewer teams. And after that, the competition continued to grow. In 2008, 44 Russian teams took part in the national round, and it became the largest national round in the world. So by the overall number of teams, it was second only to the US. And already in 2010, there was another significant step forward, and 58 universities registered to participate. For every 10 national teams, one was sent to participate in the international round, and that meant that sometimes Russia sent up to 7 teams at the international round. So what's most important? As soon as the Russian round was organized, as soon as Russian teams started to participate, there was a new round, a new era. The information became available. Before this, it was impossible to find any information. The thing is that there was no Google at the time, and you couldn't just Google information. If you didn't know what you were looking for, you wouldn't find it. And it is especially important for mooting. This is not part of the traditional education. So Russian students had no idea that this was actually something happening in the world. And Jessup is not the only international program out there. So in spite of the fact that in 2002, the information became available, but already in the first year, participants realized that their universities did not have enough information that would successfully prepare them for the competition. The preparation for the competition is not a task that can be achieved in 2 days or even a week. It requires several months, 9 or more, of thorough studies, reviews of hundreds of sources of international law, national law, international case law, commentaries, journal articles, specialist books. If you don't do this, you cannot participate. That is, you can participate, but the best teams prepare in this way. We're talking about hundreds of sources that have to be processed very carefully. Russian teams immediately found that there were no foreign language books in libraries. There were no legal databases giving access to practically unlimited sources of national law, international court decisions, and journal articles for more than 100 years. These databases are available in law schools in developed nations, but in Russia they did not exist. Moreover, the Russian teams also had to deal with the fact that there was no tradition of mooting. It was a completely new format for the Russian education system. We had no one who had ever participated in a competition of that kind, and we definitely had no one who ever won a competition of that kind. In 2003, a Russian team from the Mary State University reached the finals and became the runner-up in the international rounds. they found the secret to success because their university decided to institutionally support this team. Also, we're past that slide, but for a long time, and that's 2007, even though they were quite successful, their success did not lead to a larger success for Russian teams. It did not change the situation. So the example of the Mariel team showed that it was possible, but we didn't have a key to success. Later, we realized that Russian teams going to Washington found themselves in a situation when one team would get kicked out of the round very quickly. So many universities, most Russian teams, had the lack of understanding and support from the university administration, from their tutors. And the teams that would come back from the international rounds, if they did not win, faced heavy criticism from their school. Why go if you did not win? There were virtually no visiting professors from abroad in Russian law schools. And like in Oxford, for instance, we heard about it, the dialogue is part of education. Moot courts, interactive lessons, something that would help students. We still do not have it. Even today, the universities do not have access to largest legal databases, Westlaw, LexisNexis, etc. Only 10 Russian law schools have their own databases. That's 10 out of several hundred. We went to the school administration and said, why cannot you install such a database? And the answers that university provides is the same. We have very few English-speaking students, about 5%. So it's not interesting, we don't want to bear the cost.
So as a result of that, Russian schools do not have access to these international databases, neither the faculty nor the students themselves. I don't really believe that we only have 5% of English-speaking or English-reading students. I think we have much more, and this would potentially need to motivate the universities to get access to those databases. I know that my time is running out right now, so let me move on to the success stories that we've had. Unfortunately, these success stories are happening against all odds. These are usually individual achievements, a result of unimaginable efforts, so something needs to be changed. In Russia, yes, in the past years, several Russian teams have advanced to the international level. Last year, only one team from the Moscow State University reached the advanced rounds, but it won for Russia. Why did the Moscow State University win? I think that through all these years, the Russian universities have been able to ensure some succession. Students became trainers, and university management has also ensured in some universities access to international databases. Well, of course, it happened later than in the European universities and other universities. Nevertheless, they do have access to that information. Then the Russian National Administration, and thanks to the sponsors, we have been able to invite judges to Russia. So we have had very good information exchange and experience exchange. Some judges came here, and our former participants are now becoming judges in international rounds, and they are held in a very good regard there. We have also seen a friendship emerging with the students. I remember the Moscow State University participants were supported by the whole room. And that victory was a result of working with a trainer from the UK. They had been trained for half a year through Skype, and they came number 7. As a result, I hope that we're going to see more success stories in other parts of Russian science, not only in legal science. Thank you very much.
Thank you, Maria, very much. I'd like to thank the students here, because I've seen from my experience that some of the students here are tremendously impressive. The more opportunities in mooting they have, the better. And I look forward to the day when Russia appears throughout the world in international tribunals with its own representatives. very, very welcome contribution. I did note that Maria seemed to regard it as a bad thing, that if students got back to their universities not having won, they faced criticism. I can only say from experience in practice that that's very good preparation for real life, because clients usually have the same attitude. Our next speaker is Nick Allard. He is the Joseph Cray Dean and Professor of Law at Brooklyn Law School. He is an expert in an enormous range of legal subjects, from telecommunications to health and environmental law. And he's also a partner at Patton Boggs, where he has co-chaired what's called the government advocacy practice. As I understand it, that means that he's not just an academic, but he's also a mover and shaker who tells the American government what to do. So it's all his fault.
Thank you. Yes, I'm a legend in my own mind. Right. So thank you, Michael. Gaetano, Dean Shavalova, Timothy, my friend, and Vasily, Maria, Frank, it's just a privilege to be on a panel, such a distinguished panel. I'm sure, because he told me this, that Michael kept me till near the end because he knows that everything from Brooklyn is exciting and will liven things up, and our law school is right at the center of all the excitement in the Brooklyn Renaissance. In fact, since Michael made a little advertisement for the Oxford programs, let me say that Professor Lawrence Solon is here in the second row, spoke yesterday. He's our Director of International Programming. I have a dream of 100 Russian students from St. Petersburg in the very near future. So if you want to sign up for our 2-year JD program, which we just launched, and overseas students who have a high proficiency in English are welcome. Or if you want the traditional 1-year LLM, he's the man to see, and he'll give you a very good deal, I assure you. You all know this about Brooklyn because Brooklyn, there's so many people in the audience probably who have friends or relatives that live there. Brooklyn is the center of the Russian population in the United States, and it is the Russians, expats, Russian Americans who are leading the developments in the arts, sports, architecture, and especially entrepreneurial new business leads. So that's all very good. Now, by way of introduction, I should say that I'm a legal hermaphrodite and a humanist. Now, for the translator to ease their way, I'll let you know, remind you that a hermaphrodite is an organism that has organs from both genders. And so I have the organs of a practitioner and the organs of an academic. And I think that that helps me. And increasingly in American law schools, they are looking to people with that dual kind of capacity. And I hope that it's as fertile a way to go as it is in the biological arena. I'm a humanist, and that means that I work hard and struggle to make sure that that technology serves us and that we don't serve technology. It's also another reason why I never speak with a PowerPoint, because I like to avoid some of the inevitable pitfalls that happen. I thought very briefly I'd speak to you about three things with you, about three things. One is the transformation on private practice, on the practice of law caused by technology. Second, the transformation of legal education. And then third, some of the huge challenges that we're facing it all in just a very few minutes. So I'll just hit the high notes. Now, technology, as we always know, is disruptive. And this has always been the case. Our required reading on that topic is Ecclesiastes 1:9, the prophet. As you all will recall, that's the chapter about the eternal cycle of water and the phrase, there is no new thing under the sun. I embrace and agree with my friend Timothy Endicott about, the comfortable, well-worn shoe of the Oxford tutorial, and that there are certain universally eternal things that you want to learn how to do, and that unique educational experience is valuable. But there truly are new things and new challenges created by technology that are unavoidable. With respect to practice, there's good news. and there's no way to discuss the impact on legal education of technology without discussing how legal practice has been transformed and is changing, because after all, part of the dual mission of law schools is professional training to get people ready for law practice. So as the dean from St. Petersburg was explaining, there are some things that clients will no longer pay for. They will no longer pay for simple research, for duplication, for proofreading, for calendaring, for example. They will no longer pay for a young lawyer to fill a seat in a hearing waiting for me to arrive. They won't do that. They will not pay for things that can be done more efficiently and effectively by people who don't necessarily have a law degree or by software. Now, this is good news, because what clients will pay for and what is still required is what I call the 3 A's: analysis, advice, and advocacy. And since that is the direction that the legal profession is heading, that's very good news, because that is a profession that is worth the investment that you put into gaining your legal education and the hard work that you put in earning your degree. So in effect, the impact of technology, which is to force people to look for more economies, is driving a very welcome change. Now, there's always disruption and change, and in fact, there are lots of jobs that have been eliminated, but there are new jobs that are being creative in the legal world, and it's a question of finding them and preparing students for them. The impact on legal education is profound. Now, there's the professional training element of law school and also the scholarly mission. Technology impacts both. When I was being considered to be a law dean, I was always asked by the faculty, given the two missions, which side would you tip towards, the practical training side or the theoretical side? This was not a friendly question from the faculty. And my answer was, you have to do both. We certainly have to prepare students to be ready, as the dean said, to practice when they leave, and that's one of the things that Brooklyn Law School has a great reputation in doing. They say that America doesn't make things anymore. In Brooklyn, we make good lawyers. But in addition, it's precisely because our students, only about 98% of them are going to go into private practice, and probably less than 2% are going to go into academics or teach. It's precisely because of that, because this is the last time in their lives that they will be immersed, because it's their terminal degree, in an intellectual community. We have to provide them with life skills on how to learn and solve problems that no one has ever seen before, and to be leaders in tomorrow's market, not just today's. So that's what we're striving for. Now, first, technology is changing what you have to know. Things as abstract as jurisdiction and conflicts law, for example, which are two classic subjects, are completely transformed, as is, for example, privacy and security law issues. And that is because borders are porous, and the modern advanced communications creates us to completely rethink those theoretical subjects. The common law, for example, always evolved and changed largely by comparing dissimilar things. You take a contracts principle and apply it to tort law, for example. And then also there was always a healthy element of serendipity. Computer technology, the way we search for precedents, computer technology only compares and looks for similar things. And so I don't think we completely comprehend the impact of new technology that it will have invisibly in shaping the ways we think about things. If you want to grasp what I'm talking about, consider the way I read the news as opposed to the way our students read the news. I read a newspaper. Like Vasily, I love books. I rather fondle a book than curl up with a laptop. But when I read the newspaper, and I may be looking for the sports story or the front page story about President Obama's problems with the Internal Revenue Service, I come across a story about the Gabon viper in the National Zoo. It catches my eye. I read it, and I learned that the Gabon viper is a most beautiful snake with the deadliest poison. I learned something about Gabon, and then perhaps, maybe not, it enriches my life, and I use it later on in my life. Similarly, when you use computer technology, you skip over the serendipity of that kind of learning. So I think it's going to have a profound shape and impact on our lives in ways that we don't understand. Now, fast forward, how do we teach? There are practical and theoretical courses in law school. Both are important. There's an increasing body of knowledge that says that practical teaching is better done hands-on, face-to-face, by the individuals with their sleeves rolled up. Mooting is an example of practical training. It's a very good example. And by the way, I invite you to send a team to Brooklyn Law School for our Prince competition. Last year we had 78 teams from throughout the United States and around the world, and we'd love to see you. And I'd love to send some people for your moot court competition here. So law schools are moving towards more practical training and different kinds of practical training. Washington and Lee Law School, for example, has the entire third year outside of the traditional classroom. If you are sitting in a classroom, you're doing some kind of simulation course, but it's not sitting, hearing a lecture, and taking an exam. The most impacts of modern technology, advanced technology, is in the realm of theoretical training, and it's in that area that many people believe that if all forms of higher education don't find more creative ways in the way that Gaetano was speaking about in using computer technology to have a better delivery of educational experiences, then they're going to fall by the wayside. One of the central questions in any law school is, what kind of a library do you need? You know, why do you need all those volumes? My 3 children graduated from Princeton University. We were in a rut in my family. All 3 of them went to Princeton, and not one of them ever set foot inside of the glorious Princeton Firestone Library. Correction, they went there once to look up my senior thesis, but in order to tell me that not one person in 35 years ever checked it out. All right, so I'll just, because the time is short, just end there, and not end there, but end that phase there and say that the theoretical side is posing great demands for new ways of learning as effectively as the standard approach. What are some of the challenges? The biggest challenge, I think, is to avoid the fad. You want to avoid the academic version of the Nehru jacket. Now, I can look out here and I see that almost everybody in this audience is too young to know what I'm talking about. But I will tell you that I have hanging in my closet a Nehru jacket from the 1970s. That was a fad that passed through the United States and Britain and lasted about 3 weeks. Right? So you don't want to adopt an academic found. You want to adopt using new technology and having new approaches that are fundamentally academically sound, that make sense, and that are enduring. So that's a big challenge. Second, we in the States at least, and I can't speak for other jurisdictions, but we are regulated. We have to answer to a higher authority, not just my board of trustees and my faculty. We have to answer to the American Bar Association and the state bars, which are each individually charged with admitting our new lawyers to practice and permitting them to practice. They pose enormous constraints. We might as well be using the pipe roll of Henry I from, I believe, what century, Timothy, was that? Was that the 14th century, the 13th century? I never got it. Or maybe it was before then, the 12th century. For example, the American Bar Association says that of your 85 to 88 credits that you need to graduate from law school, only 11 can be taken online. But they have many other requirements. So, for example, you can't take any classes online until you've already earned 28 credits. So, for example, in our 2-year JD program, which again I commend to the students of St. Petersburg to consider, we had thought that the first 5 credits in the first summer would be very well taken if they were offered online, and we would still be maintaining very high academic quality. That was not possible. Even worse, some of the state bar exams require that, in effect, I'm going to oversimplify this to make the point, that they require that the online class be offered simultaneously. In other words, that the teaching and the learning be happening at the same instant. So this makes online educational options nothing more than, say, having an overflow room and an extra television set to be able to watch somebody giving a lecture. And so it greatly diminishes the worthwhile. That's a lot. There's a lot more that can be said. I think this is a very exciting time for higher education, but the greatest impact that really we have not yet explicitly addressed, it's been implicit in everybody's comments, is, and it's a cliche, is that this technology has an effect because of the wonder of mobile, advanced broadband communications, shrunk the world. We're all in it together. And increasingly, fundamentally, lawyers will be at the cutting edge of making the world work, but in a way where law and being a lawyer increasingly means being a lawyer of the world. In the past in law school, we studied international courses, international law, the law of the European Union privacy policy directive, immigration law or mass migration law in Europe, and so on. Now, what we need to consider is, what do you need to know to be a lawyer operating in a global legal environment where boundaries are porous and insensitive to geopolitical ideas and constraints? And that, I think, is something that was addressed very powerfully by your Prime Minister yesterday, and I think that in that regard, he was giving you a glimpse of a very interesting future for lawyers. Thank you very much.
Well, thank you very much, Nick. Lawyers are supposed to be versatile, able to adapt from case to case, and as a legal hermaphrodite, I think you take versatility to new heights. I did note, though, some consistency in your theme and our St. Petersburg theme from Ms. Shevaleva. Both of you talked about teaching people to learn across a lifetime and lifetime learning skills. And I can say from practice that that's one of the most valuable qualities that we look for in the people that we use, and I'm sure your firm does as well. Our last speaker today, before the questions, is Mr. Frank Astill, who is the director of the University of Sydney Law Extension Committee. He describes that as a very accessible nighttime law school. I'm not sure whether that's because of time zones, and maybe if it's simultaneous teaching, there are lots of Australian academics up in the middle of the night. But at any rate, it describes itself as having a web campus, which is a novel concept I hope he will introduce to us, and also on the internet, which is very revealing these days. He's been very frank about some of the problems of distance learning, and in particular, one of the ethical issues and challenges of making sure that students submitting work across the internet are actually submitting their own work. And it'd be very interesting if he could talk about some of those issues too. But at any rate, he's going to introduce the web campus. Thank you.
Thanks, Michael. I wonder if I could try a preemptive strike first. One of the big advantages of speaking last is that you get to consider the wisdom of what's gone before you. And in the light of that, and also in the light of the fact that to have almost 100 people at an international forum on legal education is extremely unusual. I can tell you that from experience. To take advantage of that, Michael, if I might, I want to ask a few questions. How many students do we have in the room? And we can count people in blue as well. Thanks. That's a good smattering. How many practitioners who just practice but don't teach? How many practitioners? how many people who practice and teach law as well? And how many people who are university law teachers? Thanks. Are there categories I've left out that have offended people? Anybody wish to identify another category? Oh, that's you and me. That's you and me, Nick. But the next question I'd like to ask, if I may, is did anybody come into the room with an idea that they had a burning question about what is the future of legal education? What is the most important question in legal education? I'm trying to take advantage of the fact that we have so many people here today. Does anybody come with that question? Yeah. Can I just take the question now? Of course. Yes?
Please ask the speaker to use the microphone. The booth is not getting the question, please. Everybody, please use the microphones. Okay. I urgently need to understand something about distance learning in the legal profession, and I need to understand the practical comparison, the comparison between the existing practice, between the current practice and its reflection or its accommodation in legal education. In reality, the existing textbooks lag way behind practical enforcement of current law. I would very much like to hear something about resolving this issue at the level of legal education, please.
Thank you very much. That's a question that's right on point in terms of what Michael was suggesting we might spend some time talking about. The question is, distance legal education, how does it cope with information today, the lag in textbooks? How do we actually use distance education? Are there any other burning questions? What is the most pressing thing in legal education? Can I come to that in a minute? Firstly, I want to revert to the script now, and part of the reason for finding out who we were is to test a couple of assumptions that I've made and a couple of challenges that I think I'd make to some of the comments that have already been made. The big changes, to my mind, in legal education over the last 20 years, first and probably most dramatic, there's so much more of it. There are many more law schools now than there were. There are many more than have ever been recommended in any report that's been done on how many there should be. There are various reasons why they have proliferated, but they have. There are significant consequences for that. Secondly, legal education has become much more academic. I grew up in a world where the norm was to do law virtually as an apprentice to a lawyer. And there was a combination of on-the-ground experience and learning at the university. It has now become very much a university-based qualification. And again, I think more's the pity. Nick mentioned that there's been a move to incorporate a degree of practice back into law. That's quite possibly as a result of a major study about 5 years ago, which echoed what most of us were thinking, and that is that the almost total focus on law as a liberal degree, as an academic degree, wasn't doing anybody much good. Our feeling is that most law students, and it'd be interesting to hear what you have to say, would actually like to do a law degree that equips you for practice, even if they have no idea, no concept of going into practice. That's what they want. So I'll leave that just there for the moment, but I think the implications of all of that are quite profound. Law students have changed. Most of our law degrees work on the premise that a student is a full-time student, which is patently wrong. Students are working, so that there's a clash already. And if we're looking at distance education, in one sense, most students are learning by distance education because they are, in fact, spending most of their time away from the campus. Distance education itself, it seems to me, is a two-edged sword. We've seen a rush to mass production of law students. We've seen a lot of online offerings that probably aren't particularly good. But the main point that I would like to make, and the way that we try to do it, is to maintain an emphasis on face-to-face contact. We ask people to come to weekend schools, to travel for intensive classes. We also run an evening program for people who live locally. But we try to maintain that person-to-person contact because we think, along with a couple of expressed opinions here, that the classroom is the place to learn law. So that's one point. To keep up with technology, to use technology to keep up with law is another very significant question, and it goes to the heart of what you were asking. Natalie mentioned, and there's a parallel with a comment that Tim made, that students, probably better than us, know how to manage information on the web. Tim, I think, also mentioned that writing hasn't changed much. I'm probably taking them out of context, but I'd like to comment on both of those concepts because, in our view, one of the great challenges we face, and it's one that we face as teachers and students face as learners, is how to actually discern and use the information at our disposal. And Nick mentioned the proliferation of material. But our view is that we are currently living in something of a transition period, and that none of us really knows how best to use and what the techniques are to manage the information that is at our disposal. How this seems to translate for us is what we are afraid is some sort of a decline in assignment writing and exam script writing. In a common law world, we look for a reasoned argument. We look for something based on relevant material and something that is persuasive. What we are increasingly seeing is the kind of dot point equivalent, the kind of executive summary, the kind of I'll get some information together and I'll spray it onto a page result that doesn't do anybody a great deal of good. The ability to process the information seems more critical now than it ever has been. In terms of writing changing, well, that crosses over that fairly dramatically. We think that the nature of writing, the nature of interpretation has changed somewhat, and we need to work out how to deal with it. What we're trying to do is to increase our problem analysis emphases and to put a lot of time into generic skills. As a lighter throwaway line, I suppose, there's one obvious way that writing has changed, and it's become far more illegible. And for those of us who do concentrate on 3-hour end-of-year exams, it's getting very, very difficult because very few people now ever sit down and write for any length of time. So that in itself is a challenge, which we can't overlook. A few other points that I'd just like to make, and then I think we should break for questions. The value of other teaching methods, I heartily endorse Maria's devotion to mooting. A law librarian said to me once, you can recognise the difference between somebody preparing for a moot and somebody writing an essay. They're just more alive. They've got a focus, they're searching, and that's what we want. We also want to share with students and to be able to appreciate how to make better use of lectures. Lectures have been maligned for too long, but they are such a potent teaching vehicle, particularly in times of reduced finances. So, what is the future of legal education? I think there are challenges. There are challenges within universities, particularly as they move to more business-orientated models, and particularly as they cut back on the value of teaching as such. Law somehow has been dragged along, in our experience, into models that don't suit it in terms of education. But I think we all have to be optimistic. I think that we have to learn from our students. I think that it's an exciting challenge to harness the best of technology, and the opportunities for real-time online seminars will get better. The opportunities for making selective use of online presentations will get better. I think the advent of and the popularity of movements like TED, like the appreciation of good speaking, will bring back the notion of advocacy as a value to legal education. So I don't think we have to look at all of the negative sides. I think we can say, let's see how, as a cooperative venture, we can take legal education into its very relevant future. Thank you, Michael.
Thank you very much, Frank. It's very interesting to hear about a law school which is embracing technology so fully, but at the same time respecting the need to preserve old skills of persuasion and reasoned argument. And maybe that's one of the big challenges that we face in this changing world. Now, we have made an effort to get some students here, and not just boring old practitioners. And at the end of the day, education is for students, and I hope that some of them here have got some views on what they've heard and also on what they would like to see in their education for the future. Do we have a question from a student? We've got a few. Do we have a microphone?
Добрый день, меня зовут
Good morning, I'm Uliana Strashko. I am a master level student at the St. Petersburg State University. And I have a question, or rather a comment to Mr. Frank Russell. He asked about the different categories of people that are present in this audience, but he forgot to mention one important category: students who are practicing lawyers. In St. Petersburg State University, you can find a lot of such students. And I would like to say a few words about the master program at our university. We have 2 days at the university, and that means that a lot of students have enough time to practice. So we get education, we practice, and we get a lot of skills skills outside the university. And my question is to all the speakers. Do you think that when we spend too much time on practice within the university, we lose the classical education at the university? Do you think that university perhaps should concentrate on theory alone and practical skills can be acquired outside the university, on the job, by working as a lawyer? Do you think that maybe we are losing the classical model through excess concentration on practical skills in the university?
Very much for that question, which is very relevant in terms of today's needs for education whilst people are working. I know that Nick would like to answer it. Thank you.
Yeah. Thank you very much. That was a great observation. Now, as Frank's attorney in his defense, I would note that he did mention the phenomena of so many law students working. And in fact, I think that, at least in the States, maybe Australia as well, is a very common feature of the legal education, is that you work in part out of necessity to pay for your education and in part to get practical experience. The answer to the question is one of balance. Law school has a dual mission. Its mission is to prepare people for practice, and its mission is also to prepare people to be critical thinkers and leaders, and it's a place of scholarship. You can only do that if your faculty is capable of providing practical training, but also leading scholarship. And it's a tension, so it's a question of balance. I don't believe personally that the law schools should tip one way or the other. They need to pursue both. In fact, when I took moral philosophy at Oxford University in the Middle Ages, long before Timothy Endicott was there, there's only two things that I remember from moral philosophy. The first thing is, if I'm alone in the woods and I say something and my wife Marla is not there, I'm still wrong. All right? That's a pretty good joke. Come on, you can laugh at that. Second is, if there's difficult questions like the one you pose, the answer is to challenge the question. And I think that the idea is that you need both. It's not an either-or situation. Now, I'll take this opportunity to make one comment about one aspect of technology that's affecting you every day and poses a new challenge for lawyers and legal educators. And that is the phenomena of culturally new communications technology makes people expect instant gratification all the time, around the clock. In the States, we say 24/7. Law, just take two aspects of it when it's practiced, is supposed to be reflective, careful, deliberative, giving advice, like a doctor, first do no harm, carefully do your research. But lawyers also have to go where their clients are. So clients increasingly are expecting instant answers, instant advice in an ever more complicated situation. And then the other element of it, which is really difficult, this is a challenge for the profession, is the idea of conflicts checks. So all of us who have had practical training know that when you're taking in a new assignment, sometimes the most laborious, most difficult is before you do work, you make sure that you don't have a conflict. And if you're in a large law firm or a large company, it's very difficult sometimes, and it takes time. Well, if your young lawyers are told that to advance their careers, they need to comment immediately on the latest legislation or the latest case, they may be making in new media a comment that is contrary to one of the law firm's clients without knowing it. So these elements, the speed that's exponentially imposed on the practice of law, as in other business environments, is a big new challenge. And you're going to be somebody, I don't know the answer, I just know the question. You're going to be somebody who finds the answer to that.
Thank you very much, Nick. Do we have any other questions? Gentleman at the back there, could someone pass the microphone?
The speaker is not using the microphone. Thank you. I apologize for that. I will start again. My question is this. I'm a student at the bachelor's level at the St. Petersburg State University. This is a question that I am sure would interest a lot of students. How do you overcome the psychological barrier that practicing lawyers create for students? Students who study at the university and do not have an opportunity to start practicing while at university. Because we can see that the requirements for former students are very high, sometimes too high, and the students cannot possibly meet these requirements. In 5 minutes, there will be a presentation of the International Legal Academy at the staircase. We're waiting for you there. This is an announcement. So if you can answer this question, I would be very happy.
I think. So we're obviously clearly expected there. And given that, can I just respond to your question very quickly in this way? First, what I have seen of the students here from St. Petersburg University who've been helping shows that they are a credit to your university and country. And I think that you are very self-effacing. I'm very confident that you have the skills to become and challenge practitioners. And secondly, maybe there happens here what does in the UK with practitioners visiting universities. If not, it's very important because you do need that interplay so that the student understands what's expected and the practitioners understand what's coming to them. So can I suggest that on that basis, perhaps, I think Maria would like to respond as well.
Have you finished? Я хотела просто сказать вам, что вы подумайте.
Let me just tell you this. Where do these requirements come from? Maybe international legal firms can find students like that somewhere else. And this is again a consequence of what I have been talking before. International corporations, legal corporations, and legal firms look for something in the students in other countries, and they want to see the same in our students. And the fact that sometimes our educational system does not meet these requirements, that's our problem. You say you cannot meet the requirements of legal firms. That's what I was saying before. You should think about it seriously. Good afternoon, Anton Selivanovsky, the Graduate School of Economics, Law Department. My question is from a different sphere. How do lawyers talk to non-lawyers? That's what I'm going to ask about. Does legal education ever include some elements of this talking to non-lawyers? Because a lot of non-lawyers say, well, we don't understand what the lawyers say. And the non-lawyers also say that lawyers offer different tools and mechanisms without actually understanding what is happening. I had a conversation with the Dean of Oxford University on the Law and Finance program. There are several such programs, and there are several elements to the program. There's a financial element and a legal element. And in our graduate school, our master program includes the two elements, economics and law. And we find that there's a problem of communication between lawyers and non-lawyers. So I would like to hear, how do you manage that at your universities?
Experienced lawyers spend far too much time talking to each other and not to normal people. Nick?
Well, I think in a brief, lawyers who cannot speak to non-lawyers are called professors. And lawyers who speak to non-lawyers well have clients, and they're in practice. So I think in a nutshell, that's the answer. And I don't mean to be too flip. What you're pointing your finger on is a very important skill, and that is how to communicate to non-lawyers who are actually, they're the consumers of legal services. And it may be that in the conventional model of law school, where there was too much erudite, airy-fairy, law of the banana type of theoretical pursuits, that maybe have lost some sight. But it's a very good question.
I'm sorry, we've got very limited time, and I know we've got one more question from a student. Can we take that, and then perhaps we can just have a final comment? Could somebody pass you the microphone? Yes, you've got it.
Добрый день.
Good afternoon, Sofia Prokhorova. I'm a third-year student at the Law School of St. Petersburg State University. First of all, I would like to support everything that Maria Isayeva said about the Jessup Cup, because I myself was on the team of our law school twice, and it was an invaluable experience that I could only acquire as part of that team. I think that this role play should be implemented in various legal areas. I can see that it helps not only to learn to write properly, to structure your arguments properly. It is indeed a great experience. My question is to the professors, to the teachers of law. We talked today about how legal profession should educate the students, what legal education be structured about. But what do you think about modern students? What image do you have when you think about a modern student?
That's a very good question to end on. I would like each of the professors to give a very short answer. Can we say 20 seconds each for their impression of modern students?
They kind of changed a lot since when I was a student. I mean, I remember, I guess, 4 years of law school, I never asked a question. I just shut up in the back and asked all my colleagues. Now they're becoming more challenging. They're more interested. They actually study a lot. They invest a lot of their time and their energy, and they ask challenging questions. I mean, so every time you walk in the classroom, you're always afraid they're going to ask you something you don't know. And so then you postpone it for the next lecture in which you will have the answer. But it's becoming extremely, I mean, a really great job to teach the modern students.
I'm going to agree with that. The model student, there is no particular person because they're so diverse, different backgrounds, different abilities, different gifts, different subjects they've studied before they study law. But one common feature in an excellent law student is that there's always the danger for the teacher that the student will ask a question that puts what the teacher is saying in a new perspective and makes life difficult for the teacher. That actually makes teaching exciting, not horrible. So that's, I agree with Gaetano.
An ideal student is the one who asks questions, but also the kind of student that can hear the answer and that can get this answer and apply it in his work and study.
Curious, courageous, and creative.
The 20-second rule was followed.
Quiet and busy, and spending too little time taking part in competitions. There are competitions from space to right down the bottom of the sea. Get involved in those and you'll do well.
Well, I'm not formally in academia, so...
Well, teach people mooting, which is...
No,
What's your impression?
They're actually smart, much smarter than we used to be, and I think they actually are even born, I have such a feeling, with a certain amount of information kind of, you know, already kind of, how to say, technically inserted into their minds. That's actually scary at times. I think, yeah, I think a young law student is a brilliant, which just needs to be revealed, basically. They have everything.
ladies and gentlemen, students, there is your answer. You may be nervous when you go in to see your professor and deliver your essay, but what you've learned today is they're all absolutely terrified of you. Thank you very much for coming along to the session.